matter of Gray and Mulberry Company Design Limited.
Yes.
Yes,
Mills.
my lord, yes. My lady, my lords, I appear with my especially known junior, Miss Barrett, sitting behind me, for the appellant hereafter, the claimant, my learned friend, Mr. Sadiq, for the respondent. Quick bit of housekeeping first. We've inserted a couple of extra authorities, and I say we, this is a collective effort. There are
Yes.
both sides are culpable, as it were. Behind tab 16, you now have the Court of Appeal version of Ben Carbuche, which is, in some respects, more helpful to the present point than the rather esoteric analysis of state immunity in the Supreme Court. You also have they not been inserted? In which case they're in a loose leaf. Grand. I'll turn to them as necessary, but you also have in the loose leaf form two authorities put forward by my learned friend, Arrowsmith and Page. You have the ICR report of this decision,
Yes.
the head note of which is perhaps of some importance, and at your, my lord's entirely understandable invitation, you have section 11 of the Copyright Design and Patents Act 1998, but also section 215, which covers designs, as well as section 11, which covers other works. My lady, my lords, this appeal concerns the...
Just a minute, Mr. Wilson.
Of course.
You've kindly given us all these things, but we'd better find homes for them.
Yes, let's do that first.
Tails for a result. Can we get rid of Ben Carbuche?
In the Supreme Court, you can indeed. Means that I can get rid of the wet towel I need to understand the decision, but yes, it's the Court of Appeal analysis which is significant.
Files will explode from having so many authorities.
I don't have tabs in mine, so it's quite hard to find them all.
Well, that's my apologies for that, my lady. We can get some.
Yes, well, I'm in the same position, and therefore I think it would be helpful if you could sing out the page numbers in the bundle, because although it's not tabbed, the authorities bundle is paginated.
That's understood.
I found Ben Carbuche, which is at page...
Yes, page 247 through to 289 can come out. And then the sequence that we've adopted after page 348, which is the conclusion of the material provisions of the Charter, Arrowsmith, Page, ICR report of the present case, and the two relevant provisions of the 1988 Copyright Act. Right. My lady, my lords, this appeal concerns the three essential building blocks to an indirect discrimination complaint.
Is the direct discrimination, the decision below rejecting the direct discrimination claim challenged on appeal?
Categorically not. It was the subject of the original notice to the EAT, prepared by Ms. Gray, then acting in person. It's not been pursued ever since. So you beat me to one of the first housekeeping matters I was going to raise. And we are solely focused upon indirect discrimination and the three building blocks: the definition of a protected characteristic here, belief, disadvantage, and justification. The one important point to bear in mind in the indirect discrimination context, and this is something I will return to, is of course there is no knowledge requirement for an indirect discrimination complaint. Since the ratio of the decision first instance, which of course is where this court's scrutiny must principally lie, is that the belief wasn't protected. The narrow view is that if you're with the claimant on that point, the appeal succeeds. I, on her behalf, urge this court to go further, not just for this case, but for the others which may follow it in relation to other beliefs, to consider the manifestation question in full, the correct approach to particular disadvantage, and justification. Certainly, the President of the EAT, when granting leave below to this court, regarded the first two of those as being of some considerable public importance, and of course the claimant respectfully agrees with that. Turning first to the background, I address this in some detail at paragraphs 3 to 12 of my submissions. That's pages 14 onwards in the core bundle. And I don't propose to rehearse the contents of those paragraphs in full. There are, however, 5 points worthy of emphasis on that background, and I'll address them in turn. Firstly, the belief in question. The belief being the ownership of one's own creative work and intellectual property as a fundamental human right in a free and democratic society, or expressed in the judgment as the statutory human and moral right to own the copyright and moral rights of one's own creative works and output. It's important to emphasise both the width of that belief and the long-standing nature of it in the claimant's case. Firstly, it was wider than just her.
But is it that belief in all circumstances, or is it that belief as qualified by, for example, sections 11 and 215 of the 1988 Act?
Well, central to the belief is the right to personally express, and that includes the right to ply one's wares when conducting works. There's nothing inconsistent with the belief in ownership with also the right to, or the ability and willingness to transfer aspects of that ownership, say in the course of employment. So in my view, there's no disconnect between those two. Plainly, the belief on the claimant's case as presented at first instance was qualified by the fact that material produced in the course of employment belonged to the employer. And this is where we see at the outset of the ET's treatment of belief. Paragraph 5.5, page 115 of the core bundle. The evidence demonstrated that it ought to have been read with an exception, except when that creative work or output is produced on behalf of an employer. We say that's part and parcel of the belief. There's no need to read an exception into the belief. the claimant was at liberty to be employed and therefore produce work for the employer, but it's still her work and it's her choice to transfer that work in the course of employment.
What do you mean choice? Sorry. What do you mean choice to transfer? It's not choice. As a matter of law.
Well, what I mean by choice is she chose to work with a particular employer,
Yes.
and the legal consequences of that choice is that work produced in the course of employment belongs to the employer. That's where the choice
She
comes.
accepts that is
Absolutely.
the legal position.
Yes.
And that's part and parcel of her belief.
And she has accepted it throughout. She accepted it at first instance and has done it so ever since.
Well, then it seems with respect that your paragraph 4 of your skeleton argument, the quotation is not accurate.
Well, save that. I've returned to what I said a few moments ago, which is part of that belief is that one may choose to apply one's wares, one may choose to confer ownership, i.e. one may choose to be employed, say as an artist, as a writer, whatever it might be, and confer ownership to that material produced in the course of employment.
Right.
Part of the manifestation of owning something is the choice and freedom to confer ownership. And that's what she did at the point of commencing employment.
You speak in terms of transferring and of conferring, but the point about Section 11 and Section 215 is that they provide that the first owner is the employer. So there's no question of any transfer. Upon the rights coming into existence, the very first owner is the employer.
Yes. The choice comes in at the point of starting employment. I choose to be engaged by this employer, and as a consequence, the works that I produce in the course of that employment are legally, automatically, the possession of the employer. The point I make at this stage is that that's not a qualifier in my submission. Inherent in the right of ownership is the right to confer ownership. That is legally, automatically the case at the point of commencing employment. Certainly the fact that there is any legal exception to that does not minimise the belief or render it any less cogent. It is part and parcel of the belief itself. My lord looks somewhat vexed. I'm not sure if I can assist.
Well, I'm not sure whether the belief is that ownership of one's own creative work and intellectual property is a fundamental human right, etc. Except that work produced in the course of your employment will belong to your employer, or whether it's without that qualification. That does seem to me to make a difference.
Well, the position of the claimant throughout has been that work produced in the course of employment axiomatically belongs to the employer. That's perfectly consonant with the belief. The choice comes in at the outset. Do I choose to work with this individual? Do I choose to confer ownership, which is the necessary consequence of employment? The central point is that that is not inconsistent with the belief. Because she is choosing to do as she wishes with the fruits of her creative endeavours, i.e. transfer them automatically by commencing employment. To the extent that the tribunal saw a disconnect between that qualifier and a belief that was sufficiently cogent as to meet the Equality Act test, we say that's erroneous. In fact, a rather helpful passage of the claimant's witness statement deals with that. page 60 of the supplemental bundle. And it's paragraph 22. The last couple of lines on page 60. I became passionate about my belief in the right of an individual not only to own but to profit from and receive credit for their own work if they wished. But the point I make at this stage is a question of width. It was wider than her. The belief was not confined to her particular circumstances. That is a belief that all individuals possess that right, she being one of those individuals. Of course, the tribunal must have realised that, because if the belief was solely confined to her personal circumstances, it would not have crossed the thresholds that it did when applying the Granger test. The second point in relation to the belief is the breadth of time. By the time of the claimant's dismissal, she had spent some 11 years in creative industries, and studies included screenwriting and creative writing. She was accepted prior to commencing her employment on an unconditional basis to study a PhD in creative writing, and as set out in my submissions, she had produced a screenplay that was shortlisted at the Sundance Festival precisely on the copyright issue. She was writing long before 2005, but the professionalisation of it started in 2005. The claimant also adduced evidence as to the role it played in her life. And if we are back in the supplemental bundle, it's page 45. Last paragraph of the material produced at the preliminary hearing. I write as a practice in my daily life, as a way to see and understand the world, as a means to express my devotion to the path I am on and to the guidance and of nameless and invisible dimensions. Incidentally, whilst we're in the supplementary bundle, we see the claimant's CV at page 65. And no need to necessarily turn it up, but for the purposes of page referencing, the claimant's witness statement dealt with the creative ownership rights screenplay at paragraph 22, pages 60 and 61. Secondly, that belief has recognition in both domestic and international law. We see an aspect of that in the Copyright Act 1988. Article 27 of the Universal Declaration of Human Rights. You have it in the authorities bundle, but it's also cited at paragraph 5 of my submissions. And doubtless also there's an interplay between that belief and Articles 10 and Article 1, Protocol 1 of the Convention. The third point to make is that the claimant's approach was not blinkered, but rather it was nuanced. In this sense, the claimant was content, and indeed happy to do this at the outset of her employment, to sign and subscribe to clause 13 of the contract, page 7 of the supplemental bundle.
Yes.
Why is that of any relevance? It's concerned with inventions.
Well, it's of relevance in this respect. There's an express reference to the 1988 Act, and it imposes a positive requirement to take all necessary steps to transfer title. covers improvements and designs. The further relevance, I would say, is that the claimant had no issue whatsoever with the phrase during the course of your employment, which is used in clause 13, and that phrase is not mirrored in the agreement. The relevance of that, we say, becomes particularly clear when considering the justification question. The agreement that she was unable to sign is that at page 8. All copyright works, and it's clause 2, all copyright works or designs originated, conceived, written or made by you alone or with others during the period of your service. And we see the phrase during the period of your service repeated at 2.2. And then 2.4, you agree and undertake you will do all such things and acts as may be necessary or desirable to substantiate the rights and respects of the matters above. In other
This was
words,
the original
yes,
version.
Yes.
And there's a great deal of toing and froing. Page 10 is the amended version, and she refuses to sign that, so they say they go back to the original.
well, 60, and the key point for the purpose of the claimant's case, well, the key juncture is the 16th of September 2015, and at that point, because that is the complaint of indirect discrimination she pursues, not the requirement to sign an amended version. The focus of her complaint is what takes place on the 16th of September.
But it's relevant, isn't it?
Of course it's relevant.
She had refused to sign an amended version.
It is plainly of some relevance.
Because if she'd
The
signed
picture.
that, she wouldn't have been required to sign the original.
Yes, that would follow.
Well, can we look at the amended version?
Yes.
Page 10. In what respect does that go beyond section 11 of the 1988 Act?
2.1 continues to use the phrase during the period of your service.
Sorry, what's wrong with that?
There is a distinction in my submission, my lady, between during the period of service and in the course of employment.
But then the amended version goes on a lot longer, which relate to any business of Mulberry Company or any matter arising from your employment with Mulberry.
Yes. Well, consider that clause absent the limitation of in the course of employment, my lord. And what we would say is this. A screenplay, a novel, which was inspired by colleagues, where characterization of individuals is based on perhaps colleagues, would not be in the course of employment, but it would relate to business or arise from employment, or at least it was capable of doing so.
Right?
My submission, that is capable of being broader than the course of employment test.
But does it not follow that the essential disagreement between the parties was as to the precise wording of the proposed copyright agreement, and in particular the breadth of the assignment of works concerning in one way or another employment? And is that not relevant to the question of whether there's any discrimination, it seems a little difficult at first to see how a dispute as to the breadth of a copyright assignment, and in particular the precise wording as to the transfer of works relating to employment, can be the subject matter of a discrimination claim.
Well, in order to get there, we have to presume that a belief exists along the lines of what the claimant was advancing, i.e. a belief in the ownership of creative works in accordance with the law, i.e. once one chooses to be employed, one is conferring rights automatically for those works produced in the course of employment. And the respondent's position is that it has no interest in any works created outside the course of employment. And if one accepts that that is capable of being a protected belief,
Sorry, what's capable of being protected? I thought the belief was the claimant's belief, not the respondent's belief.
I wasn't suggesting anything different. No.
Sorry.
No. If one accepts that the claimant's belief is capable of being protected under the Equality Act, a requirement to surrender anything greater in one's individual works, one's creative output, is plainly capable of constituting a disadvantage, we say. I mean, on one level, it may be about wording, but if the wording was intended to have any effect, it entails a greater infringement on that belief, necessarily.
So even if the infringement is consistent with the law, it's nonetheless a disadvantage to her because it goes outside her own particular belief about how the law should operate in her particular case. Is that fair?
My lady, that's not what I'm saying. What I'm saying is that certainly a reading of both the original, and we say also the amended version, is that it goes beyond Section 11 of the
Her,
215.
as the respondent, you said, accepted that it had no interest in any works created outside employment. And indeed, I think there's a finding by the tribunal at 5.6 that
That it had no such interest.
yes.
Yes.
So on the respondent's case, it's acting entirely in accordance with the Copyright Act and Section 11. But you say the claimant's belief, or rather the disadvantage imposed on the claimant as a consequence of this copyright agreement is a disadvantage to her as a believer in her belief, because in her view it goes wider than...
I make that point, but I also make a more fundamental point, which is the natural reading of the agreement goes beyond the statute. Notwithstanding what the respondent stated its intentions and interests were, the wording of the agreement is not limited to material in the course of employment. It refers to during the period of service.
Well, the tribunal didn't reach any concluded view that it was necessarily unenforceable.
No, and it may not be unenforceable if that was what the agreement intended to achieve. If the agreement was anything produced at any stage during the course or during your period of service becomes ours, and parties willingly signed up to that agreement, there's no need why it would necessarily be unenforceable. The parties are free to agree as they wish. But the disconnect in my submission, my lady, is that the natural reading or the natural wording of the agreement goes beyond the stated intentions or objectives of this employer. That is not a reason to find against the claimant.
Who is that a question for? What is the natural meaning? those words? For the Employment Tribunal? For us?
Well, in the context of a discrimination complaint, disadvantage is gauged by reference to the reasonable impression of the claimant. And the claimant's view, which was not altogether unreasonable, is that the wording of this agreement imposed a greater infringement on her, the freedom to practice her belief.
No, that's not what she said. She said being required to sign it was a disadvantage.
Yes.
She didn't communicate her belief at all, as the tribunal found. So the disadvantage is simply the requirement to sign it, and if you refuse, being dismissed.
Yes.
There was no communication, as the tribunal found, of her belief.
Well, it was certainly not fully elaborated or anything of that
More than
nature.
that, the tribunal found in terms that she didn't, either in her private conversations or at any time in the course of these negotiations, say anything or elucidate her beliefs to the respondent at all. That's paragraph 4.11.
Yes. What was conveyed on the material provided by the respondent is page 75 of the supplemental bundle, Miss Hayward's statement provided on behalf of the respondent.
Well, are you asking us to go behind the finding at paragraph 4.11?
I'm not, but it needs to be read in context, my lady, of the material that the respondent itself put forward. She said that the claimant said that she had an interest in writing and filmmaking outside of work and was concerned that the copyright clause would legally bind her into having to assign any work she created over to Mulberry. Now, I do not seek to go behind the tribunal's finding that the precise formulation of the belief that was advanced before the tribunal and is advanced before you was communicated in so many words. But
It wasn't. We do need to look at the findings of fact because they are unassailable, as you know, in this court. I think you're saying that even if your submission is that even if she kept the belief entirely to herself, that nevertheless she can succeed.
my submission is certainly that there is no requirement for an indirect discrimination complaint to express in any particular formulation the belief, provided that the manifestation test is made out. In other words, manifestation is not solely to be assessed by the knowledge of the employer. Because there is no knowledge requirement in an indirect discrimination complaint. And I will, of course, address you on the manifestation principles in due course. But my point number 4, as it were, so one, the nature and extent of the belief; 2, the recognition of that belief in domestic and international law; 3, the claimant's approach was not blinkered, was not nuanced; 4, which I was touching on to, is that there is no suggestion in the present case of the claimant acting in anything other than good faith. And if I can take you, my lord, to page 83 of the supplemental bundle, sent from Ms. Wilkinson. Paragraph 14. We both wanted the same outcome, and the conclusion of paragraph, subsequent on paragraph 16, page 84, completely unnecessary for her to lose her job over this.
Well, you've got a finding in your favour at 5.7.1, actually, that the belief was genuinely held. She honestly believed it.
Quite so. Yes. The fifth point on background, finally, is that whilst the respondent was at one point prepared to countenance the claimant signing a looser clause, her dismissal was predicated upon the ultimatum of signing the original wider clause or facing the loss of employment. That was first presented at the initial meeting on the 16th of September 2015. And it's important to note that, therefore, by common consensus, contrary to 4.16 of the Tribunal's judgment, there was no second amendment, there was simply one amendment. So 4.16 is an error. And where the Tribunal...
What do you mean it's an error?
Well, paragraph 4.16 suggests that there were two amendments. There was not, there was one. But by the time of the 16th of September, the clause which one is looking at is the original clause.
Yeah.
And so when we look to page 5.18, for example, and this is something which is an error which is repeated in my learned friend's submissions, the clause which is said to be very close to the that which the claimant presented is not the is the amended clause. The proximity is not with the original clause, which was the reason.
You say the amended clause is irrelevant.
I say it can only have the claim is predicated upon the requirement to sign the original clause on the 16th of September or else face dismissal. Yeah. The amendment has a role to play in the justification at the justification stage, and we say that in some respects that cuts both ways, because if the amended clause would have satisfied the respondent's purposes, firstly, any notion that there needed to be a uniform approach can't be relied upon, because the respondent was willing to tailor a clause for the claimant. It was not a case where all 1,500 employees had to sign precisely the same clause. And secondly, if the
So what?
Well, there's an element, it seems on the Tribunal's analysis that the need for uniformity plays some role in the justification test, i.e. there was a need for a consensus and universal approach. Yeah. Plainly that's not what happened, because the respondent would have been willing to countenance an individual and tailor-made amendment. The second point is that when one is considering justification, the question is, does a disadvantageous step go further than necessary? If a looser clause or a diluted clause would have satisfied the respondent's purposes, it cannot be for it to say that the original clause was necessary.
So you're saying they offer a concession, she says no, therefore they must lose the case because it shows that the harder line agreement was not necessary.
Went further than necessary.
Simple.
I do say that's part
the
of
end
it.
of the case.
Well, I've got a few hills to climb.
I think you do.
Before that.
But anyway, that's very straightforward.
Yes.
Yes.
Starting point, of course, is belief.
Yes.
And of course, the focus of this tribunal, of this court, must be on the tribunal's reasoning below.
Yes.
At first instance. The belief is as set out at paragraph 3.2, page 111. And then we have the Granger test.
Well, just before we go into Granger, we have to read 3.2 along with 5.5, don't we?
Yes. Although you have my submissions on that. The exception is not. In truth, there is no exception. The two are perfectly consonant with one another, and essentially the decision to work for an employer and confer creative work or output accordingly is in accordance with that belief rather than an exception to it. We then have the Granger analysis at 5.7, page 116. And perhaps worth turning up Granger whilst looking at this. That is a tab tab 5.
Yes. Give a page number, please, Mr. Wilson.
Yes, of course, 91.
Thank you.
And for present purposes, the first two paragraphs of the head note will suffice. A philosophical belief within the meaning of Regulation 2.1b of 2003 regulations is a belief genuinely held and not merely an opinion or viewpoint as to a weighty and substantial aspect of human life and behaviour that has a certain level of cogency, seriousness, cohesion and importance, worthy of respect in a democratic society, not incompatible with human dignity or in conflict with the human rights of others. A belief is not precluded from the protection of the regulations merely because it is not shared by others or does not govern the entirety of the believer's life or does not constitute or allude to a fully fledged system of thought or is based on a political philosophy or on science. That's the broad thrust of Granger. And at 5.7 the tribunal applied it to the present case. 5.7.1 genuine belief. And the belief that's being tested here is that as it's set out at paragraph 3, 3.2. Secondly, that belief was not just an opinion based on logic, but was a viewpoint held by her as a belief. And the significance of that, we say, is that that sits uneasily with the notion that this was solely in the context of a particular clause or a particular proposed agreement. That would not meet the McClintock test. This was held as a belief. Thirdly, that belief covered a weighty and substantial aspect of human life and behaviour. Of course, 5.7.4 is the challenge, but just concluding those aspects where the tribunal was with us, where the belief was worthy of respect in a democratic society. Genuinely held as a belief, weighty and substantial aspects of human life, worthy of respect in a democratic society. Where the tribunal was against the claim, of course, is on the certain level of cogency, seriousness, cohesion and importance. And the reasoning it adopts is firstly to postulate a spectrum. On the one hand, an individual who lobbied and campaigned, and on the other, somebody who would simply ask if they agree with the notion that copyright theft is a bad thing. Doesn't seek to place the claimant within that spectrum it envisages. Then, again, talks hypothetically as to a person simply agreeing with the notion that copyright theft was a bad thing would hold a belief.
We've gone back from Granger to the tribunal
have,
of
I'm sorry,
5.7.4.
yes.
That's fine.
It was clear in my mind, but not in my signposting. My apologies. And we're on page 117, my lord, of the core bundle. Whilst we accepted the claimant strongly believed in the right of ownership to her own creative output, we did not accept she held that belief as any sort of philosophical touchstone to her life, not sufficiently cohesive to form any cogent belief system. The individual's right to create, produce and write, and the benefit that she had from those activities, which was something entirely different. The observation I would make at this stage is that if the belief were confined to her, it's difficult to see how it would satisfy the other tests. There is no cross-appeal in relation to the elements where the tribunal found in her favour. If I may, therefore, with that reasoning in mind, turn to the broad points on the correct approach to defining belief. And again, there are 5 points I would seek to make. Firstly, it's vital that the courts do not wade into the substantive merits or demerits of a particular belief, or on its merits. That is for the reasons which Lord Walker in particular gave in Williamson, tab 2, paragraph 57, dangerous waters. One does not gaze into the rationality of, or otherwise of a belief or its manifestation. Not every facet of the five great faiths would necessarily pass that threshold. And we see again in Williamson, paragraph 24, a recognition that many of those faiths include an element of the supernatural. Moreover, one's free to believe as one wishes, as Baroness Hale put it in paragraph 76. It is only where the belief impacts on others or is manifested that there is any need for that test. But as I'll explore in due course, the test applies not to the manifestation, but to the belief. Secondly, there's to be no difference in treatment between a religious and a secular belief. My lady will be very familiar with her own decision in Henderson. I don't therefore need to turn it up. Tab 12, paragraph 62 is the relevant passage. This has important implications when it comes to proving indirect discrimination in my submission. Now, before the EAT, I have asked submissions as to what was meant by the removal of the word similar from the 2003 regulations. I do not suggest that a secular belief needs to be subject to some lower pass mark when it comes to assessing cogency, cohesion, etc. What I do say is that when considering the modest requirements of satisfying that test, and that's a phrase from Williamson, to which I'll turn in a moment, one must be alive to the particular nature of the belief in issue. Not every secular belief has an organised church or a single text. It's not any less cogent or coherent for the absence of those elements. There may not be regimented prayer cycles or regularised services, but a secular belief may nonetheless satisfy the cogency, coherency threshold.
So in other words, you say although the threshold isn't lower, it's not higher either.
It's certainly not higher, and there are dangers in seeking to read across what one may find in an orthodox faith to a secular, non-religious belief. Thirdly, inherent in the recognition of all beliefs, and in particular minority beliefs, is the need to avoid setting the bar too high, and here I will turn to Williamson first. Tab 2. And it's page 29. To paragraph 22 of Lord Nichols' judgment, what I made earlier. Emphatically, it's not for the court to embark upon an inquiry into the asserted belief and judge its validity by some objective standard. Maybe intensely personal and can easily vary from one individual to another. And then paragraph 23, everyone therefore is entitled to hold whatever belief he wishes, but when questions of manifestation arise, as they usually do in this type of case, a belief must satisfy some modest objective minimum requirement. And then over the page, the belief, and I say again, not the manifestation, the belief must be consistent with basic standards of human dignity or integrity. The belief must relate to matters that are more than merely trivial. We see there the reference to the supernatural by B. It is not always susceptible to lucid exposition or still less rational justification. The language used is often in the language of allegory, symbol and metaphor. Depending on the subject matter, individuals cannot always be expected to express themselves with cogency or precision. In the present case, that passage is of particular importance. Then paragraph 24, by E, these beliefs are placed on an equal footing for the purpose of this guarantee of freedom. Thus, if its manifestation is to attract proper protection under Article 9, a non-religious belief, as much as a religious belief, must satisfy the modest threshold requirements implicit in this article. The then President of the AT, Mr. Justice Langstaff, considered Williamson in the case of Harron, at page 239 first. And page 240. The belief must also be coherent in the sense of being intelligible and capable of being understood.
Sorry, where have you gone to now?
This is the case of Harron that starts at page 239.
Right. I do have tabs because my clerk put them in, but so can you give me that?
Yes, it's tab 15.
Thank you very much.
And the first aspect of the head note refers to the fact that the Granger elements have been recognised in the explanatory notes. You have the explanatory notes at tab 20, page 315. But then at the second point, the tribunal failed to provide sufficient reasons for its decision that the claimant's belief in the proper and efficient use of public money did not qualify for protection. That's the belief that's being considered in Harron, the proper and efficient use of public money. Then on considering Williamson, suggests that the reference to a matter being more than merely trivial was a hint towards the approach that regards as substantial that which is more than merely trivial. Coherence is to be understood in the sense of being intelligible and capable of being understood. Clearly the belief that the claimant would have met that test if the test had been applied in isolation, a plea not to set the threshold requirements at too high a level. And the reasoning behind that, we see at paragraphs 34 onwards, that's page 244. Where that phrase, more than merely trivial, is picked up. That is a hint towards the approach that regards as substantial that which is more than merely trivial. The fact that he meant it in that sense is indicated by the word again in the expression, but again, too much should not be demanded in this regard. And so the EAT rejected the tribunal's approach where paragraph 39 of the ET's decision cited at paragraph 35 of the EAT's judgment, not so much belief but a set of values which manifest themselves as an objective or goal principally operating in the workplace, as imposing an unnecessary and inappropriate gloss on the modest requirements of a belief. As such, a belief under both the Equality Act and Article 9 of the Convention may be a one-off in two important respects, both of which addressed in Granger, tab 5, page 91, and in particular paragraphs 26 and 27 of that decision, page 101. Firstly, the belief may be held by just one individual. Hence the reference to a reader. A person could, for example, be part of a mainstream Christian religion but hold additional beliefs which are not widely shared by other Christians or indeed shared at all by anyone. And that's repeated at paragraph 27. It's not a bar to a philosophical belief being protected that if it is a one-off belief and not shared by others. And it may also be a one-off in the sense that it may only refer to one aspect of a person's life. It need not govern the entirety. And the phrase that we see at the bottom of paragraph 27, we say is central, as it was put in argument, such philosophical belief need not amount to an ism. And so we have the example in Harron of the proper and efficient use of money in the public sector, and in Maestri, which was a decision by the ET and reached this court at a commission hearing for a different matter, namely the establishment of a direct discrimination claim. No issue that the belief in the higher purpose of public sector broadcasting was capable of being a belief. That decision, tab 9, at page 155. Now, the language of more than merely trivial may be familiar to this court in the disability context. Something which is substantial, i.e. more than merely trivial in its impact, may cross in that context the disability test, and then the central focus should be upon accommodating that disability, or we say here, accommodating that belief within the workplace.
Well, disability has a reasonable adjustments requirement.
Yes.
There isn't a reasonable adjustments provision in the context of religion or belief.
No, there isn't.
So the suggestion of that parallel and the need for reasonable
There
accommodation is not real.
There is certainly not a freestanding reasonable adjustments claim in the disability context, nor do I say a belief should be strictly compared to a disability.
And although there was some controversy when these provisions were first enacted about the reach of the indirect discrimination provisions and how they might have been better framed as reasonable adjustment or reasonable accommodation provisions, Parliament has never enacted any provision to that effect in religion or belief.
That's certainly true. What I would say, my lady, in the context of justification in the indirect discrimination cases, is that often one is in that sort of territory of proportionality, not as a freestanding reasonable adjustments complaint, but the ultimate question is the extent to which Mr. Weeder wearing a cross, Mr. Liddell's beliefs should be accommodated in the context of an indirectly discriminatory PCP. So I don't say that there is a strict parallel as a freestanding complaint, but the notion of accommodation, once something has a more than trivial aspect on an individual's life, and in particular life within the workplace, I do say there are some analogies to be drawn. I put it no higher than that.
Right, well, that's probably a suitable moment to break off. So this one-off you say that a belief can be protected even if the claimant is the only person to hold it.
And I'm not the only person that says that. The EAT says that in Granger, or certainly approaches it on the basis that that's permissible.
So let's test it. Suppose that the claimant applies for a job, and before a decision is even made to offer her the job, she asks to see the standard terms of the contract of employment, and suppose the contract of employment contains a clause about copyright. She writes to the employer and she says, I must make it clear I am not willing to sign any copyright clause which goes beyond a verbatim repetition of section 11.2 and section 115 of the 1988 Act, because of my profoundly held belief that, subject to the provisos created by statute, everyone should have the right of copyrighting their own ideas. Is the evidence of my profoundly held belief. If you refuse me a job, I will take you to a tribunal. On your case, she's got a slam dunk win, hasn't she?
No, my lord.
Why not?
Because the territory I'm exploring at the moment is simply on the threshold question of belief, and I will return to disadvantage.
It's a belief that qualifies. She's
Yes.
excluded from employment. The tribunal would then have to go to whether it's necessary as a proportionate means of achieving a legitimate objective.
There may be cases where an employer professes to have a legitimate concern as to matters which go beyond the scope of the statute. There may be cases where an employer says we need absolute uniformity in the way that we treat people for a sense of morale or coherence, consistency amongst the workplace. Neither of those routes have been advanced by this employer at any stage. The broad point I make is that the threshold question of belief should not be the central gateway. Justification defence is sufficiently flexible to allow for those nuances. And those nuances may well, and perhaps in hindsight, could well have been taken by this employer. They have not been.
Okay, we'll leave it there and return to a clerk.
Thank you.
All right, 2:05. By that clock.
We'll have our hour. Thank you.